Yes.
Good evening, distinguished colleagues and fellow legal practitioners. Welcome to the second lecture of our ongoing SCAORA lecture series 2025. Today, we delve into our second paper on drafting, a fundamental skill that forms the backbone of effective legal practice. We are privileged to have with us this evening Mr. Abhinav Mukherji, Senior Advocate, who will share his expertise and insights on this critical subject. Mr. Abhinav Mukherji was designated as Senior Advocate by the Honorable Supreme Court of India, a recognition of his exceptional legal acumen and contribution to the profession. His academic excellence is evidenced by him being rewarded the gold medal in the AOR examination conducted by Supreme Court in 2009. His distinguished career involves serving as standing counsel for the state of Bihar and additional advocate general for the state of Himachal Pradesh in the Supreme Court. Currently, Sir holds the position of Additional Advocate General for the state of Bihar. Notably, he has the distinction of being the first double AG appointed by the Bihar government ever. Sir's expertise spans multiple specialized areas of law, including anti-doping law, narcotics, constitutional, civil, criminal, and commercial law. His comprehensive understanding of these diverse fields bring a unique perspective to legal drafting. Sir's formative years were shaped by training in the chambers of eminent legal luminaries, Mr. Maninder Singh, Senior Advocate, Ms. Pratibha Singh, who is the sitting judge in Delhi High Court, and the late Mr. Arun Jaitley's chamber, who was Senior Advocate and former Cabinet Minister. This exceptional mentorship has contributed significantly to his legal philosophy and approach. Beyond practice, Sir is a prolific legal writer whose articles have been featured in prominent legal blogs, newspaper, and digital platform. His expertise is regularly sought by reputed news channel for television debates on matters of legal and constitutional significance. Sir's contribution to sports law is particularly noteworthy, having served as vice chairman of the Anti-Doping Appeal Panel, India's apex appellate authority for adjudicating disputes related to the doping control in sports. As senior counsel, Sir maintains an active practice before the courts in Delhi, handling a diverse portfolio of commercial and criminal matters. Sir's involvement in the DGSCR committee and the SCR Rule Revision Committee of the Supreme Court of India demonstrates his commitment to modernizing and improving our legal system. Before starting this lecture, I would like to state that if viewers and all the viewers of this video have any question on today's subject, they may write in the chat box and we shall be taking it at the end of the lecture. Now, may I extend a warm welcome to Mr. Abhinav Mukherji, Senior Advocate, sir, as he shares his valuable insights on the art and science of legal drafting. Please, sir.
Good evening, everybody. It's a great honor and privilege to be here amongst all of you. And I'm happy that SCAORA has started this very nice endeavor. And I think they've got a good lineup of very exceptional speakers, which will really benefit all of you. So coming back to today's topic, which is your paper 2 of the exam, which is legal drafting. Now, you must keep in mind always that your written pleading is the first introduction of your case to a very, very busy judge of the Supreme Court. It is important for you to keep this in mind, because when you have this thought process in the back of your mind, you will be very careful with the choice of words, the format of your draft, how you're preparing, what language you're using, what case law, what strategy you are using. Because you must understand that on admission day, a normal court has about 60 to 70 miscellaneous items before it. And very often the level of drafting which the judge is looking at, it leaves him feeling that there is nothing in this case. You will not be correct to think that what you're writing in your paper is something which the judge is not reading. It is from personal experience, I'm telling you, that very often the judges will look at your synopsis, they will look at your list of dates, and then they will come to the impugned order. That synopsis and your list of dates is going to give the judge a flavor of what your matter is going to be about. So it is very, very important for a prospective advocate who is filing in the court to be able to have a very, very good command over the draft that he's preparing. Now, that is the foundation of your case. That is the foot in the door for you. If you are able to encapsulate what you want to say and get a judge interested in your case merely by your words, 50% of your battle is won. So, drafting is something very technical, which requires a lot of clarity and precision. It is not just stringing against a list of dates which you've taken from the High Court record and putting it there. So you must be very, very careful about it. And as an advocate on record, you have a very, very privileged position in this entire system. And which is that you are the sole master who's responsible for what you are pleaded, what you're filing, how you're filing in the court. You will get a code at the end of your clearing your exam. That is not enough. It is your primary responsibility to the institution that you elucidate what your client wants to say or what your instructing advocate feels about the case in the proper perspective before the court. Now, you will also note that once you made this draft, it is you who is personally certifying the correctness of the pleadings, the correctness of the annexures, the correctness of the translation, the correctness of the verification in the affidavit, everything that's on your shoulders. So it's not enough to say that, okay, I've now filed it and I've signed it and that's the end. No, whatever you've done is your responsibility. And that responsibility requires a lot of strategic thinking on your part as a prospective advocate, how you're going to frame your matter, what are the reliefs you're going to seek, and what grounds you will argue, what questions of law you are involved. In fact, a lot of petitions we have been looking at, they are a plethora of grounds. They are like ZZ, double J, all that is there. But believe me, if you are able to get 5, 6 good grounds in your petition, that is more than enough. If you're able to get 2 good questions of law, 3 good questions of law, that is much more than enough. So you also understand that the bulk of the cases are under Article 136 today. And that's a completely discretionary remedy. So it's not even an appeal. So it's all the more important that your draft, when you start it, how you focus upon the important things which you've just outlined is there. Now, you look at the exam pattern. It is in paper, which there are 4 parts of this paper. And the duration, I think, is 3 hours. And your maximum marks are 100. You get about 30 minutes to read the question paper. So the common grievance which we also had in our time was that, this paper is so lengthy, we are not able to finish it because it's handwritten, etc. So that 30 minutes time is the time which you use properly to understand the question. Please look at what the examiner is asking for. Please understand the questions where you will be able to do them properly for yourself. Don't gloss over the words. Very often what happens is the examiner has asked you, tell us, given you a set of facts and said, write the grounds of the SLP. But then there are people who have made synopsis, list of dates, question law, and grounds. So if somebody has asked you only for grounds, give only the grounds. If an examiner has asked you questions of law, give only those. So keep that in mind, understand the question properly in those 30 minutes, identify the questions which you would like to answer, and then proceed with your paper. Now, before you proceed with the paper, one important thing you must note is that many of you are out of practice. You're not writing on an everyday basis. So please give adequate margins on both sides of the paper. Please give adequate clarity to the handwriting and then proceed. So when I wrote the exam, I remember I did what I used to do in school, which is draw margins on both sides of the paper and give gaps between finishing an answer and then starting the next answer very neatly. And if you have time, underline something which you think is extremely important in your draft. So these are small things which would probably help you. When you are looking at the question, depending on what the question examiner is asking for, divide how much time you would place on each question. So if you think that there's a question which involves, let's say, a full SLP to be made, and you've chosen to do that, so then divide a little more time for it. For something which is smaller, let's say somebody asked you only for a condonation of delay application. That's a very small, minuscule application. So put less time for that. So this is how you should utilize the first 30 minutes, reading, understanding, dividing your time, and identifying what you're going to write. And the other thing is, to help you save time, you must memorize all the templates. There is no two ways about it. So you must memorize an appeal template, you must memorize your SLP templates, you must memorize your original suit templates, your application templates, all that your colleagues at the bar would be happy to help with. And I think if SCAORA has a booklet on templates, etc., it could be very, very useful for the aspirants. Now, look at the last few years of the papers, you will see there is this pattern where usually the questions are on SLPs, which is a special leave petitions, criminal and civil. So now the draft is identical for both. Public interest litigation, SLP is sometimes broken up into different parts, synopsis, list of dates, cause title also. Now that's a very important aspect where many people falter because you don't look at the cause title. Now, there are three types of cause title in the Supreme Court. One is for criminal and civil appeals or statutory appeals. One is for SLPs, which are arising out of civil proceedings. And criminal matters, sometimes they ask you for cause title with the trial court as well in it. So you must know how to make the trial court, the Supreme Court, the trial court, the High Court, and the Supreme Court cause title together. So these are things you must keep in mind. It's a very neglected aspect. Then apart from that, you must know how to frame your certificate. That's also a question which comes. Affidavits, that's a very, very important part. In the affidavits, you must take special care to know how the verification reads, what is the language of the 2-3 paras which you have to add. The verification part is also important because there are a plethora of judgments of the Supreme Court on the aspect of defective verification and the consequences of that. So you must understand this part and you must apply it yourself. The other aspects which I've seen which are coming in the papers are transfer petitions. Now their transfer petitions are of criminal matters and of civil matters. The grounds and prayer we have already said. Condonation of delay applications, applications for directions, interim relief. So these kind of things, you must know the foundations and you must know the formats of. Now, when we also look at the format of the Supreme Court rules, you will notice that there are also other applications which are mentioned, which are like, for instance, bringing on record legal errors, setting aside abatement, curative petitions, writ petitions under Article 32, election petitions, original suits. So each of them have different distinct formats. So some will be with a list of dates and synopsis. Memo of parties is obviously different. Some will be without a list of dates and synopsis. For instance, original suits are without that. They have just a memo of parties and then the constitutional, under Article 131, the constitutional framework. And in terms of that constitutional framework, whatever your averments are. And we borrow heavily from the CPC in relation to these kind of suits. So you must be aware of how a plaint is framed. What are the reliefs you could seek? Who are the parties to an original suit in 131? So only states. So you'll get all the law, etc. on that. Now, other than that, I have seen questions on the anticipatory bail, etc. Now, in relation to the Supreme Court rules, if you could now have a look at your system which the court has in the 2013 rules. So you will look at, there is a general section. The general section gives you instances of affidavits. It tells you how the affidavits are. It tells you how notices of motion have to be framed. So you must know the templates for the affidavits, notices of motion, etc. In the original jurisdiction of the Supreme Court, we have the suits, the transfer petitions, the 32 petitions and all. The appellate jurisdiction is your normal appeals, etc., which we are filing, including 136. And then review and curative. Curative is an extremely rare jurisdiction. The original suits are there between Order 25 to Order 37. The petitions under 32 are there in Order 38. TPs are similarly there after that. And special references are also there. Now, coming to the special references, you must understand that these are references under respective laws like Income Tax Act, reference under 143. Now, for election petitions are there, presidential references are there, and Article 3117 references are there. For Article 143 references, there is no set template because that is a reference which is made by the President of India to the Supreme Court. So perhaps if you are asked, you could think about the current reference which has gone. You could read up on that. That's a very interesting topic. And when you do a 143 reference, it will be in the form of questions, which the President is asking the Supreme Court to answer. But when you do that aspect, you must keep in mind one important factor, the law on 143, that it cannot be used to override existing judgments. It is only advisory. So look up the law on the references. I don't know if they will ask you because that's a very live topic this time. They might ask you to make certain questions to test you in terms of framing the questions and whether you're aware of the law. Similarly, reference under income tax is also made by the tribunal under, I think it's 254 or 257 of the income tax. And that is in case the tribunal sees there's a conflict of judgments. So you must know the nuances of the references in the rules. The Article 317 references are again for removal of members of the Public Service Commission, and there is no set template for them because they are again references made where references come to the court through the office of the governor or the president, and then the court takes a process to answer those references. The important part is for you to know what kind of references are there, what are the legal aspects which you can frame for these kind of references. For transfer petitions, you must know the relevant grounds of why you're seeking transfer. They should be there with a lot of clarity, those 3-4 grounds. The petitions under 32 now are very important. So 32, as you know, is a constitutional right available to everybody. 32 could be for habeas corpus. It could be for PILs. So when you are framing, let's say, a PIL, in your draft, you must be able to frame it in terms of the locus of the writ petitioner before the court, the bona fides of the writ petitioner. What are the previous cases which the writ petitioner would have done? What are the reliefs you are asking for? Who are the parties against which you are claiming the reliefs? And why have you come to the Supreme Court? Are there any similar cases pending which are there in the high courts? Why have you not gone to your parent high court? So all these things are to be captured in your draft in a 32 petition dealing with your public interest litigation. When you look at a normal Article 32 for enforcement of fundamental rights, let's say you're given a question that, there is a notification which impinges on the business of a particular company, draft an Article 32. So you must be aware that 32 would not lie only at the instance of a company. It would have to be an individual citizen as well. So when you are drafting these petitions, you must know the nuances of the law and who will be parties. So you will make a company a party, you will make an individual shareholder director a party, then you will frame your petition according to the other respondents. Choice of respondents is also very, very important. Choice of grounds is very, very important. So these are things which you need to keep in mind as far as your petition number 32 are concerned. Original suits, we have already discussed. It will be only between one state and another, or the union and states, etc., etc. Original suits are very difficult to conceive because most of you have not probably done it. But I can tell you, it borrows a lot from the CPC. The procedures which the court follows for original suits are also borrowed from the CPC. So when you are drafting it, you will keep that in your mind. Only thing is there will be no synopsis and list of dates and all. The reliefs will also be molded according to what is being sought for. So the original suits are very different in the sense that it could be dispute between two states over, let's say, for instance, Bihar and Jharkhand had a long-standing dispute over the power plant. Who will own the power plant? It all stemmed from the organization of Bihar and Jharkhand into separate states. So that's the kind of disputes you'll see. Or you'll see between Himachal, Punjab, and Haryana over the water sharing of the canals, etc. So when you frame the reliefs, it has to be done very creatively. I would suggest that you look at all the judgments on these aspects. You will get a flavor of the kind of disputes which have come before the Supreme Court in 131. And you will also get to know what are the kinds of reliefs which were granted by the court and why they were granted and who were the parties. So you will have to look at all the CPC provisions and look at how the plaints are, the names of the plaintiff, which will always be a state, the name of a defendant, which will be the contesting either the central government, which is the Union of India, or the state, etc. Then the cause of action para is very important in an original suit because you have to plead and aver that this is the cause of action, this is within limitation, and the jurisdiction of the court is made out for the relief. So the facts showing that the court has jurisdiction in the original suit have to be very, very properly pleaded. And obviously then in this suit, there will be lists of documents, etc. Now remember one thing, in the original suit, there are no annexures. So it will be just, you will plead the documents, you will plead your facts, and it will be like a normal civil suit where you add the documents in a list of documents and place it before the court. You could also be asked in an original suit to why the plaint should be rejected. Now, please remember that in the CPC, there is Order 7, Rule 11, A to D. Here, it just says where it does not disclose a cause of action or it is barred by any law. So there are certain deviations from the CPC which you need to know when you look at an original suit. Then in this as well, written statement, set off, counterclaim, etc. are there, like in a normal original suit in the original side of any court. So you can also have a look at Order 29, which talks about how pleadings have to be done in this kind of a matter. And the sum and substance of this is that it has to be in a very concise and crisp form with dates, sums, numbers expressed in figures and in words. So whatever you do, please adhere to this. And then we've already discussed about your Article 32 petitions. Please pay very, very proper attention to the prayer part, whether you're asking for certiorari, whether you're asking for prohibition, mandamus, habeas corpus, quo warranto. Be aware of the limitations of these writs when you ask for a 32. There is a special provision for habeas corpus in the rules. Please pay attention to that when you're asking for reliefs under that, because you are effectively asking for release of somebody in illegal custody and production. Now, this is as far as the habeas corpus part is concerned. So when you're drafting the grounds in your Article 32, you must specifically aver which are the fundamental rights of yours which are being violated. So 14, 19, and 21 in terms of Maneka Gandhi, which is your holy trinity or triangle. You must make out if you have any grounds on arbitrariness. Now, obviously, legislation is also being challenged on the ground that it's arbitrary. Earlier, that was not the case. If you're challenging, let's say, any statutory authorities order in the 32, then if you are alleging non-application of mind or a violation of principles of natural justice or non-following of the procedure under the law applicable, all those things have to be very, very concisely pleaded and put forth. If there is any element of promissory estoppel, legitimate expectation, these are the normal grounds which we put in a writ petition, whether it's in the High Court or whether it is here. Now, coming back to the aspect of your 32s, you must understand that the 32 is, though it's a constitutional right, but the court is very, very reluctant nowadays, and they want you to go to the High Court. This aspect you must keep in mind, and you must make out very compelling reason in your synopsis itself why this matter should be entertained by the Supreme Court. That is very, very important. Otherwise, you will again risk that the judge will say, why don't you go back to the High Court? So circumstances where the Supreme Court entertains 32s are if there's a problem which you have highlighted, which are there in many states. So if there's 2, 3, 4, 5 states involved, then obviously a litigant can't be expected to go to 5 different high courts. So then a 32 might be the remedy for you. There is a very egregious violation of fundamental rights of a class of citizens. Then also the court might decide to look at it. Or it raises such a compelling constitutional and legal issue that the court says, okay, I'll look at it myself. So these are the kind of very, very glaring situations under which the Supreme Court feels that it should look at a 32 petition. So this is as far as 32 are concerned. Now, when we look at transfer petitions, we'll look at the CPC and we will look at the BNSS now, first while CRPC. These have very, very limited grounds on which you will ask for transfer. Most of these are for matrimonial issues and all in the civil side, and very limited grounds of transfer of criminal trials or criminal cases outside the jurisdiction of the court where they are. So be aware of those grounds and be very, very mindful of the fact that it's a very, very discretionary remedy, and compelling synopsis again and compelling list of dates, very, very factual brief. Now, what happens normally in these transfer petitions is that you give the whole history, geography of, what happened with the husband and what happened with the wife, or what happened in X situation and Y situation. Now, all that the court doesn't look at, it is immaterial. So your petitions for transfer should only have the very, very basic facts. When you got married, who is gone where, which court, what proceeding started first, second, why are you asking for transfer, and from where to where. Now, these 5, 6 things should be enough. Your TP should be a very, very thin kind of a document, not like I have seen sometimes, like you start from day 1 and go into day 25. I understand that sometimes the lawyers are told by the client, you write this, you write that, you write this cruelty, you write this, this person said this, but that is not the issue. The issue is which court will hear a case and why. So you must be mindful of that and look at it like that. The references we've already spoken about. The 257 of the income tax I've discussed with you. Statutory tribunals we've discussed. Now coming to the appellate jurisdiction of the court. So the appeals are there under Order 18, Rule 1. Civil appeals are there under Order 19, Rule 3. Criminal appeals under Order 20 as well on certificate. Special leave petitions 136, civil and criminal. That's the mainstay. And appeals under the special acts. So appeals under special acts would be, for instance, statutory appeals under the Consumer Protection Act or Advocates Act. So things like that. So you must be aware of the specific grounds in each of these enactments. For instance, the NGT Act. So NGT Act says questions of law of substantial importance, etc., etc. So every act has a different code, and you must be aware of all the kinds of statutory appeals which are provided under the various enactments. and the limited grounds available. Those grounds must be very, very clearly made out. They must be kept right at the beginning itself. You must mention in the synopsis what is the biggest and the best ground you have to challenge the order of that particular tribunal or authority, so that the judge is interested in entertaining it. See, earlier when we began practice, we were always very, very relaxed, because we felt like a statutory appeal means it is 100% admission case. There was not a single statutory appeal in my time which would get rejected on the first day. But now I've seen the court has started on the first day itself dismissing these kind of appeals. So you must be aware that there is a change in the thinking of the court. And it is very important that now, at least for statutory appeals, it is not a given that on the first day the judge will say, all right, it's a statutory appeal, I have to look at it, and therefore I am going to admit it. That is now no longer the thinking. So we have to evolve with the thinking of the court. And we have to again now work hard on our synopsis and list of dates, questions of law, grounds, whatever is the requirement under that particular enactment. Coming now to the special leave petitions under 136, which is in that form 28 of the rules. Please learn that template. In your SLP, as I mentioned in the beginning of the lecture, your synopsis and list of dates have to be very, very crisp. They cannot be running into, hundreds of pages, or I think a 2-3 para synopsis and a very, very concise list of dates with 2-3 questions of law and 5-6 grounds are more than enough in many, many cases, majority of the cases, I would say. It is only our habit of keeping on writing and making a bigger and better SLP for whatever it's worth, we get into that trap. But that's not correct, because a judge is dealing with 60-70 cases. He has only that much of leeway to look at your draft, look at that case and say, okay, this is the main thing here. So I'll give you an instance. So if you are able to if you have a case where there are different viewpoints on the same issue by a high court, that should be your only thing in the synopsis, your pleading, that look, these 3 high courts have taken this view, these 4 high courts have taken this view. In my case, this is the exact issue. My high court has taken this view. It's a fit case where the court should settle the law. That is more than enough for a Supreme Court judge to look at, because that is something which will appeal to a judge in a 136, that, okay, there are conflicting judgments, I must look at it. So these are the kind of things you should bring to the forefront. Or let's say if the High Court judgment is totally contrary to the law. For instance, let's say the High Court has interfered in surplusage proceedings. Now the law is very settled. You can't have a 226 interfering in surplusage or these kind of financial proceedings. That should be your only focus in your synopsis. And the paperwork also should be linked to that. So these are the kind of focus and the narrowness with which you must approach your synopsis and your list of dates. Don't make it very rambling. Nobody is going to read it. And ultimately, your draft will not have the desired effect on the judge. You must also know when to file a SLP, criminal, and a criminal appeal. So when you look at 374 CRPC, or now it's 415 BNSS, there is a subtle difference. Sometimes the registry, even though it's a criminal judgment of the High Court on the criminal side, requires you to not file an SLP. You must be aware of the distinction. You must be aware of in which matters the SLP is required and in which matter a straightaway criminal appeal is required to be filed in the Supreme Court. So there is law on this, which you must examine and appropriately draft it. Sometimes the examiner can just give you the facts and then tell you draft an appropriate petition. So it could be an SLP, it could be a criminal appeal. So you must know the distinction in which cases there will be a criminal appeal, in which cases there will be a simpliciter criminal SLP. Limitation will also obviously be different for these. So please take that in mind. Now, civil appeals, the format is totally different from your form 28 of the SLPs. So in civil appeals, you will also look at the memo of parties differently. you will, when you're writing the civil appeal out or drafting the civil appeal out, you will must know under what section, what rule, and what act it is being filed. You must be aware of that. Mention it very, very clearly after your memo of parties when you begin the main body of the civil appeal. Again, rule is be brief in your synopsis and you're concise in your list of dates. You must know where the annexures are going to be annexed. A lot of people make the mistake of annexing their annexures in the civil appeals or criminal appeals in the list of dates itself, which is not the case. So be aware of that. Brevity again is very, very important. So this is as far as the appeal jurisdiction of the court is concerned. Now, must note one more thing. There's a difference in the contents of the civil SLP and a criminal SLP, which are there in Order 21 and Order 22. Cause title is, again, I'm stressing on it because a lot of us don't look at the cause title properly. So there you will make a mistake. Please make sure that the cause title is there. You might also get a case where they say that, okay, someone XYZ has passed away after pronouncement of judgment. So you must know in what format you will make that particular application for bringing on record the LRs, etc. If you are looking at drafting the synopsis, please consider, and this is my suggestion, that don't make it a lengthy sentence. Break up the sentences, put it in small paras. 5, 6, 7 paras are more than enough for a synopsis. So if the examiner asked you about synopsis, give only that. Don't give the list of dates. If the examiner asks you for a list of dates, give only the list of dates. Don't give him a synopsis plus list of dates. The synopsis and the list of dates together should not be more than 5, 7 pages in any SLP. That is the ideal. Even 5, 7 pages is a lot, but that is the ideal maximum length. And please be mindful of the judicial orders which have touched upon requirements of drafting uh, different kinds of synopsis. For recently, there has been a judgment in Munnesh, state of UP, which has asked the registry to ensure that the criminal antecedents are mentioned in the petitions very, very prominently in bail cases. So you must be aware of this. The judgment has also required that the details of the current stage of proceedings in the trial court, etc., are mentioned. So when you're drafting, let's say, a bail petition, you must be aware of all this. In any case, even in a bail petition, you must write that what is the stage of the trial, how many witnesses were there, how many are examined, charges framed, not framed, all those things must come out very clearly. In the list of dates and the synopsis, you must avoid quotations of your judgments unless it's a 2-3 line thing which clinches the issue in your favor. You must also avoid any kind of quotations of the sections or the enactments you're relying upon, because that's already a part of your appendix. You must also avoid all these quotations of the documentations because they are already annexed to your SLP. So please avoid that. That just makes it lengthy and repetitive. Now, moving a little away from the list of dates and synopsis, and once you become lawyers, this will be more in practicing in the court as an AOR. This will be very relevant for you. Very important is translations. Now, most of us rely upon external translators who are overworked, and there are a lot of errors. And these errors can be very, very difficult for you when you are standing in court tomorrow and going to rely on that, and you realize that, oh my God, this guy, the translation error is so bad that what will I tell the judge? So the best way to cover up that is please always, as a practice, annex the vernacular along with your English translation. That will save you a lot of problems and a lot of embarrassment. And you will not be accused of trying to hoodwink the court. Now, whatever your legal ground is, it is always a part of your grounds. But if there is a very, very compelling legal issue which you're raising, which is applicable to your case, you please do mention that in your synopsis in a few lines. For instance, let's say your case is one where it is covered by a judgment on illegal detention. For instance, Prabir Purakayasta's judgment. So you mention it that I was illegally detained on XYZ date. These are the two, three facts which show this detention. And it's directly covered by the judgment of the court. So that helps a judge to not only understand your case, but move on to some other case rather than spend like half an hour on your brief trying to understand what you're raising. It's very important for a judge. And I'm telling you, when you give a good draft to a judge, if there is even an iota of doubt where he should issue notice in your case, it will be in your favor because he will be like, okay, this person has made an effort to curtail all the verbosity. He has made an effort to put his case correctly before me. So I will give him a benefit of some discretion I have, particularly when we're looking at 136. So your substantial questions of law, moving on to that, they must be very, very well thought of. Please try to look at the law before you frame it. Just don't do it on the basis of whatever was argued in the High Court. Very often, the High Court does not get the assistance which you as lawyers are capable of giving in the Supreme Court. Please do look at the judgments of the court on a daily basis. Look at the scale. Look at the SCC, the loose parts. Look at the index. It's very tedious, but it will stand you in good stead. If you are able to spend even 15-20 minutes every day just looking at the latest scale which has come, go through the index. I'm not saying read everything, read what you find interesting. Go through the loose parts of the SEC online. You will get the gist of the judgment and it will somehow hopefully stay in your memory that, look, I read something like this. So when you get your draft for a substantial question of law, you will be able to think of the principle. Then you will look at your case, you will search for it, and you will get that. Add it to your substantial question of law. Please, when you're drafting and you're looking at an appeal in the Supreme Court or an SLP, in whatever form, be very mindful that you are dealing with a judicial order of a High Court judge who's a constitutional authority himself. We are not supposed to use words like false. The High Court judgment is not to be attacked on the ground of any derogatory language. Please avoid all that. Be very polite. Don't say that the High Court judgment has non-application of mind. Don't use words like that. Use very gentle words when you're talking about a judgment of the High Court, because all your judges have come from the High Court. Majority of judges are very sensitive to the terminology you use for their fellow service providers. So one more thing you must keep in mind, if your language against the High Court judgment is very, very harsh, the court has been taking a very dim view of these things. And one or two cases are there, unfortunately, where lawyers in the Supreme Court who are existing AORs have been proceeded with for contempt. So be very, very mindful, be very respectful to the High Court judgment. You could just say things like the High Court has omitted to consider judgment of the court and so, or the High Court fell into error in interpreting this, rather than saying that the judge has suffered from non-application of mind or the High Court judgment is illegal. These are kind of loose drafting. We avoid it. Please avoid these kind of terms. Very, very important. Now, if there are any constitutional provisions which are applicable to your case, please also use them and mention the judgments which have interpreted that particular constitutional provisions. Judges expect that of us. Grounds are again very, very succinct. There's no repetition. Please avoid it. Mention any legal infirmities in the grounds, like any jurisdictional errors, any kind of constitutional statutory rights which are available to you, which have been overlooked, or the impact of the judgment on any other kind of rights of the parties. Every ground should be self-contained. Don't break up one ground into 3 different grounds. Make it into one concise ground of a few sentences. Please be very, very mindful. Don't use long sentences. Use very short and crisp sentences. And if there are any violations of fundamental rights, etc., as a result of the action which you had impugned before the High Court, please set those out as well. Look for similar case law and add it. Well, one more important fact, many years ago, we did one case. That time I was a young AOR, and the High Court order was something to do with relationship between two parties. And the High Court had found that they had a relationship between two parties. So one of the parties appealed to the Supreme Court, and we were for the party who had succeeded in showing the relationship. And I remember we briefed a very learned leading senior lawyer who didn't look at anything. He just looked at the petition and said, yeah, I'll manage, I'll manage. And I kept thinking, ye sir, subah jaake kya karenge court mein? So it was Chief Justice's court, and this Chief Justice, as soon as the case got called out, he heard the other senior counsel. In 2 minutes, he said, yes, you're right. There is an error in the High Court judgment, and we will interfere. So the senior I had engaged just got up and said, look, the only issue is this, that there is a relationship between A and B. I can show from this very pleading the relationship. And all he did was point out the footer in the page. So the lawyer who had drafted that petition was the same lawyer for both the parties, but he had by mistake left his footer on the edge of the page, which showed that the lawyer is the common lawyer for both the people. So on that ground, only the judge started laughing and dismissed the petition. So be very careful of all this. This is nothing to do with pleading, but this is how you have framed your petition. Don't keep any telltale footers, headers, and all these things left in the petition, where the judge will feel that, okay, there is something more to this. Interim reliefs and prayers, there is a set format in the SLPs, but after that, you can add another prayer or so. So please be careful of what you are asking for in terms of, let's say, if you have, apart from the standard prayer of grant ex parte interim relief by staying the order, you can ask if it's a land dispute, that status quo be maintained over the land in relation to khasra number, whatever. So add all those. Be also very careful about redacting the names of victims of, let's say, POXO, minors, sexual assault, etc. Make sure that in the SLP, in your annexures, in your other pleadings, these names are very, very properly redacted. Don't give out these, otherwise you will be in problems. And another thing I've seen is that very often the client leaves the affidavits with you. You file the SLP, but then you realize that the affidavit is of a date previous to the documents which you're filing. So be aware of those kind of things. Affidavits are very, very important. Your affidavit should be drawn up in first person. Please divide it into paragraphs. Description of occupation, age, details of the parentage, etc. are required to be given. It must contain specific affirmation facts which the deponent is able of his to prove of his own knowledge, statements of his belief, clarity on what falls under personal knowledge is required, and information in belief. It also for SLPs and applications supporting the SLPs, the affidavit must state the specific para numbers of the synopsis, the list of dates, contents of SLP, and your application which you filed. Verification also must be very, very properly done. Please have a look at the Supreme Court rules and the CPC provisions. Certificate of the AOR is also very important because this is your liability. It's not anybody else's, because you're certifying everything which is there is your headache. It's your baby. It's your responsibility. So be very mindful of that. And you must know the language of the certificate because this question comes sometimes. So the other thing I would request you to reconsider is that very often we as lawyers write, it is respectfully submitted. Now, according to me, you can omit those words. You can straight away start with your sentence, with your submission, with your issue which you're writing about. Because every time you add those 4 words, it just leads to multiplication of those 4 words into many, many paragraphs, especially all over your draft, which makes it a very long draft. You can just write that petitioner submits or whatever else you want to say. For instance, you want to say, let's say the sentence you want to say is the verification clause is a formal declaration of XYZ. So you could just write that instead of writing it is submitted that the verification clause is a formal declaration of XYZ. Thereafter, we have the review jurisdiction and curative. Please be aware of the kind of jurisdictions which are exercised, the grounds which are available, and what are the certifications required, especially for curative. Now, please also know the liability or the responsibility of the advocate on record, weigh the pleadings, know the relevant rules, know what is it, be aware of the latest judgments so that when you are drafting, you are keeping those aspects in mind. So some recent judgments you would have seen. One is Bhagwan Singh versus State of UP, which is 2024 SEC Online Supreme Court 2599, where the court has gone into forged documents which were given, where the advocate never met the petitioner, never verified what he's filing. Court has come down very strongly on the concerned AORs, etc. Then there was one judgment of Bhavesh Kumar Manubhai Parkhia, where again the court was mindful that the language in the drafts were not correct, neither was the translations, etc. correct. Then there's a series of orders by Justice Oakes Court in relation to the omissions in the drafting by the advocate on record concerned. So these are few judgments which we have seen. There is one judgment which was recently given last year in Soumya Chaurasia, where because of the misrepresentation or the incorrect version of facts stated in the SLP, the entire SLP got rejected. So please be very, very careful. Look at the questions. Look at the answers which you are thinking of giving. And if you have some doubt about the format, etc., what you can do is you can use the last page, mark it rough work, put the template out, look at the template. In the heat of the exam or the stress of the exam, you might have left out something. So you can always do a rough work at the back of your paper, write rough work, and then look at the draft and the template, etc., sketchy, and then make it into a full draft, depending on what the question is. So this is it as far as my lecture is concerned. If you have some questions or if you have any doubts, please let me know.
Thank you, sir, for that enlightening and comprehensive discourse on legal drafting that will undoubtedly enhance our professional practice and prove invaluable for those preparing for the exams, where precise drafting skills are essential for success. Sir, in fact, most of the things we have already covered in this lecture. There are some questions which I'll read out from the chat box.
Sure.
So one of them is, what are the components of a compelling synopsis?
So like I said, your synopsis, keep it brief. Don't reiterate the factual aspect because that is coming out in your list of dates. So according to me, for instance, let's say I gave that example. If it's a matter where your client is illegally detained, so your synopsis should only have those 2 paragraphs that look, the grounds of arrest were not supplied. I was picked up on so and so date.
Right.
I was illegally taken into custody. Right. It's covered by a judgment of the Supreme Court, which in identical circumstances, in case of so and so Pura Kayastha, has held this. So that is a compelling synopsis because that will look at the judge will look at it and say, "Arey, what is this? How can someone just be picked up off the road and taken like this?
Right.
So something like that. Your compelling synopsis has to hit the judge very hard in terms of his judicial mind. It has to make the judge overcome his reluctance to interfere in your case.
Right.
Because when the judge sees 70 matters, his thinking is, I am not a court of appeal. I am a 136 court. It's discretionary. High court judge has seen everything. Why should I look at it again?
Right.
Right?
So second question we have, are questions of law necessary in statutory appeals?
Sorry, come again. I didn't understand this.
Are questions of law necessary in statutory appeals,
No,
criminal
there
appeal?
is, that depends on the act concerned. So some of them are not required. Some of the acts have, like for instance, I recollect the NGT Act has.
Right.
It has substantial question of law. So if it is an appeal against the NGT order, it will have. So you have to be mindful of those acts. Every act has a requirement which is different from the other. So look at the parent act and then you will know whether it is required or not.
Sir, we have many people asking for the templates of the drafts.
That I said, SCORA is going to give them.
Right. So
It will be
everybody
very
will be
useful
providing them to you.
if you guys can give them the templates.
Yes.
And I mean, because unfortunately, our rule only has the Form 28. The rest of it is, but I'll tell you generally, if you look at the pattern, I will tell you, for instance, a writ petition will have a synopsis, list of dates, memo of parties, then the main body of the draft,
Yes.
your all the things which you want to say, then the grounds, and then the prayer, and then a separate application for interim relief. This
Right.
is the usual format for even your other appeals. Okay.
Right.
So with minor deviations. So if it's a question of law, then there will be question of law in these kind of statutory appeals. If there's no question of law, it'll be like this. SLPs you already know. So get hold of these templates and please give it to them. It's very important.
Yes. In fact, sir, when I appeared, I followed this PDF. I have this 1000 pages are there. So there are several drafts which maybe they can use. I can share with them.
Yes, you please do that. That'll be very helpful for them.
Right. And so these messages and questions are flooding. So I'll just take one more.
Yes.
Any good example of a substantial question of law which you would say that sometimes people write in the facts and circumstances of the case, which I personally believe shouldn't be written, but something across your mind right now which you can suggest them that's how you have to go about the substantial question of law. Maybe refer to some judgments, precedents of the court, or some something, some provision of law that they can
Yes.
write.
Yes.
Yes.
So let's say if there was a statutory requirement of uh, giving notice and hearing before passing of an order,
Yes.
and the High Court has held overlooked that statutory requirement or read it down, but there is law to the contrary. So you could say whether under section so and so of the Act of so and so, the requirement of a prior hearing mandated by the statute could be omitted or ignored by the High Court and taken a contribute to the judgments of the Supreme Court and so and so and so.
Right.
Thing like that. Those are general examples I could give.
Thank you so much, sir. In fact, we still have so many messages, but we'll try and answer all of them in the notes which we'll be providing to all the
Yes, I'll
viewers.
share the notes. I'll ask the colleagues to send it.
May I, Nikhil sir, in fact,
Meenakshi, please have the vote of thanks.
may I now have Meenakshi Kalra, our member executive, to kindly give the vote of thanks.
Thank you, sir, for a wonderful lecture, actually, for discussing all the key points. I, on behalf of the Supreme Court Advocate on Record Association, I extend our heartfelt gratitude to our senior advocate, Abhinav Mukherji, sir, for being an esteemed part of the SCAORA AOR Lecture Series 2025. Your illuminating insights on drafting have been invaluable, and your expertise in highlighting the key points for drafting and considering the important paragraphs and crucial topics for the exam will undoubtedly benefit the AOR aspirants. Notably, your in-depth knowledge lends significant credibility to your guidance, providing aspirants with a first-hand understanding of what it takes to excel. Your thoughtful analysis has provided clarity on important questions, giving aspirants a significant edge. We appreciate your gracious presence, sir, and look forward to have you on board again for the SCAORA AOR lecture series. Thank you for everyone who's watched this lecture in large numbers. On behalf of SCAORA, I wish all the AOR aspirants the very best of luck for the upcoming AOR exams. Thank you
Thank you
so
for
much.
having me,
Thank you,
and
sir. Thank
wishing
you.
everybody all the best.
Thank you, sir.
Sir.
Thank you, sir.
Thank you, Nikhil sir. Thank you, Meenakshi.